हाय फ्रेंड्स, आज हम डायरेक्टिव प्रिंसिपल्स का पार्ट 2 बना रहे हैं। तो पहले भी हम डिस्कस कर लिया था इतना तक, तो सेकंड पार्ट में देखेंगे। फर्स्ट क्वेश्चन जो था यहाँ पर दिया गया है, डिस्टिंग्विश बिटवीन फंडामेंटल राइट्स एंड डायरेक्टिव प्रिंसिपल्स। फंडामेंटल राइट्स में बारे में देखेंगे। दीज आर नेगेटिव एज दे प्रोहिबिट द स्टेट फ्रॉम डूइंग सर्टेन थिंग्स when prohibited by state from doing certain things. These are justiciable, that is, they are legally enforceable by the courts of their violation. They aim to at establishing political democracy in the country. These have legal sanction. They promote the welfare of the individual, hence they are personal and individualistic. Okay, they promote the welfare and of the individual, hence the personal and individualistic. They do not require any legislation of their implementation. They are automatically enforced. The courts are bound to declare a law violative of any of the fundamental rights of unconstitutional and invalid. फंडामेंटल राइट्स हो गया। तो डायरेक्टिव प्रिंसिपल, these are positive as they require the state to do certain things. These are non-justiciable, that is, they are not legally enforceable by the courts for their violation. They are non-justiciable, that they are not legally enforceable by the courts. Here but they are enforceable legally, they are enforceable by the courts. Okay, here but they are not legally enforceable. They are aimed at establishing political democracy in the country. Okay, fundamental rights का and directive principles का, fundamental rights यहाँ पर and यहाँ पर directive principle. Fundamental rights, they aim to establishing political democracy in the country, and directive principle, they aim at establishing social and economic democracy. Okay, a political and democratic, social economic democracy. They have legal sanction. Okay, they have moral and political sanction. They promote welfare of the individual, hence they are personal and individualistic. They promote the welfare of the community, hence they are societarian and socialistic. They promote the welfare of the individual, hence they are personal and individualistic. Okay, directive principles में अगर देखा जाए तो they promote welfare and of the community, hence they are societarian and socialistic. Fundamental rights, they do not require any legislation for their implementation. They are automatically enforced. They require legislation for their implementation. They are not automatically enforced. You have automatically enforced fundamental rights. Directive principles are not automatically enforced. The courts are bound to declare a law violative of any of the fundamental rights as unconstitutional and invalid. The courts cannot declare, but the courts are bound to declare. Okay, the courts cannot declare directive principle. Okay, declare a law violative of any of the directive principles as unconstitutional and invalid. However, they can uphold the validity of the law on the ground that it was enacted to give effect to a directive. In the case of Nanda Bharati case, 1973, the Supreme Court declared the above second provision in case of Nanda Bharati case, 1973, the Supreme Court declared the above second provision of Article 31C as unconstitutional. Article 31C and invalid on the ground that judicial review is a basic feature of the Constitution and hence cannot be taken away. However, the first provision of Article 31C held to be constitutional and invalid. Okay, first provision of the Article 31C was held to be constitutional and valid. Later, 42nd Amendment Act 1976 extended the scope of the above. First provision of the 31C was constitutional and valid. Okay, but second provision invalid. 1976, 42nd Amendment Act extended the scope of the above. Okay, first provision of the Article 31C including within the protection any law to implement any of the directive principle and not merely this specified in Article 39B and C. In other words, 42nd Amendment Act accorded the position of legal primary and supremacy to the directive principle over the fundamental rights conferred by Article 14, 1931. Article 39B and C, in other words, the 42nd Amendment Act accorded the position of legal primacy. Accorded the position of the legal primacy and supremacy to the directive principle over the fundamental rights conferred by Article 14, 19, and 31. However, this extension was declared as unconstitutional and invalid by the Supreme Court in the Minerva Mills case, 1980. It means that directive principles were once again made subordinate to the fundamental rights. But the fundamental rights conferred of Article 14 and Article 19 were accepted as subordinated to the directive principles specified in Article 39BC. Okay, Article 14 and Article 19 are accepted as subordinate to the directive principle specified in Article 39B and C. Further, Article 31, right to property, was abolished by the 44th Amendment Act. 1978, right to property was abolished by the 44th Amendment Act 1978. In the Minerva Mills case, the Supreme Court also held that the Constitution is founded on the bedrock of the balance between the fundamental rights and the directive principle. In the Minerva Mills case, 1980, the Supreme Court also held that the Indian Constitution is found to be founded on the bedrock of the balance between the fundamental rights and the directive principle. They together constitute the core of commitment to social revolution. They are like two wheels of a chariot, one no less than the other, to give absolute primacy to one over the other, to harmony of the Constitution. This is harmony of the harmony of balance between the two is an essential feature of the basic structure. Disturb the harmony of the Constitution. This harmony and balance between the two on the essential essential feature of the basic structure of the Constitution. The goals set out by the directive principle have to be achieved without the abrogation to the means provided by the fundamental rights. Therefore, the present position is that the fundamental rights enjoy supremacy over the directive principle. Here, this does not means that the directive principle cannot be implemented. The Parliament can amend the fundamental rights for implementing the directive principle. The Parliament can amend the fundamental rights for implementing the directive principle, so long as the amendment does not damage or destroy the basic structure of the Constitution. Fundamental rights for implementing the directive principle so long as the amendment does not damage or destroy the basic structure of the Constitution. Implementation of directive principle. Since 1950, the successive government at the center and in the states have made several laws and formulated various programs for implementing the directive principle. These are mentioned below. The Planning Commission was established in 1950s to take up the development of the country in a planned manner. The successive 5-year plans aimed at securing socio-economic justice and reducing inequalities of income, status, and opportunities. In 2050, the Planning Commission was refilled by a new body, Niti Aayog, National Institution for Transforming India. Almost all the states have proposed land reforms, laws to bring changes in the agrarian society and to improve the condition of the rural masses. These measures includes the abolition of intermediaries like zamindars, jagirdars, inamdar, tenancy reforms like security of tenure, fair rents, etc. Imposition of selling of land holding, distribution of surplus land among the landless laborers, cooperative farming, the Minimum Wage Act 1948, the Payment of Wage Act 1936, the Payment of Bonus Act 1965, the Contract Labour Regulation and Abolition Act 1970, the Child Labour Prohibition and Regulation Act 1986, the Bonded Labour System Abolition Act 1976, the Trade Union Act 1926, the Factories Act 1948, and the Mines Act 1952. The Industrial Disputes Act 1947, the Workmen's Compensation Act 1923, and so on have been enacted to protect the interest of the labor sections. In 2006, the government banned the child labor. In 2016, Child Labor Prohibition and Regulation Act 1986 was renamed as the Child Labor and Adolescent Labor Prohibition and Regulation Act 1986. The Maternity Benefit Act 1961 and the Equal Remuneration Act 1977 have been made to protect the interest of women workers. Various measures have been taken to utilize the financial resources for promoting the common goods. This includes nationalization of life insurance, 1956, the nationalization of 14 leading commercial banks, 1969, nationalization of general insurance, 1971, abolition of private purses, 1971, and so on. Legal Services Authorities Act 1987 has established a nationwide network to provide free and competent legal aid to the poor and to organize Lok Adalats for promoting legal justice. Lok Adalat is a statutory forum for conciliatory settlement of legal disputes. It has been given the status of a civil court. Its awards are enforceable, binding on the parties, and final as no appeal lies before any court against them. Khadi and Village Insurance, Village Industries Board, Khadi and Village Industries Commission, Small Scale Industries Board, National Small Industries, Cooperative Handloom Board, Handicrafts Board, Coir Board, Silk Board, and so on have been set up for the development of cottage industries in rural areas. The Community Development Program 1952, Hill Area Development Program 1960, Drought-Prone Area Program 1973, Minimum Needs Program 1974, Integrated Rural Development 1978, Johar Rajkaj 1989, Swarna Jayanti Gramin Rajkaj 1999, Sampurna Gramin Rajkaj 2001, National Rural Employment Guarantee Program okay, 2006 and so on have been launched for raising the standard of living of people. The Wildlife Protection Act 1972, the Forest Conservation Act 1980 have been enacted. The safeguard of the wildlife and forest responsibility respectively. Hmm. Further, the Water and Air Acts have provided for the establishment of the Central and State Pollution Control Board, which has engaged in the protection of the environment. The National Forest Policy 1988 aims to conservation of development of forest or English in the okay. Agriculture has been modernized by providing improved agriculture inputs, seeds, fertilizers, irrigation facilities. Various steps are also taken to organize animal husbandry and modern and scientific lines. Three-tier Panchayat Raj system at village, okay, taluka and jila levels has been introduced to translate into reality Gandhi's dream of every village being republic. The 73rd Amendment Act 1992 has been enacted to provide constitutional status and protection to those Panchayati Raj institutions. Seats are reserved for SC, ST and other weaker sections. Education institution, government service and representative bodies. The Untouchability of Officers Offences Act 1955, which was renamed as the Protection of the Civil Rights Act 1976, Scheduled Caste and Scheduled Tribes Prevention and Atrocities Act 1986 have been enacted to protect the SC/ST from social injustice and exploitation. The 65th Constitutional Amendment Act 1990 established a National Commission for Scheduled Caste and Scheduled Tribes to try to protect the interest of the SC and ST. The 89th Constitutional Amendment Act 2003 bifurcated the combined commission into two separate bodies, namely National Commission on Scheduled Tribes for Scheduled Tribes and National Commission for Scheduled Caste. Okay. Various national level commissions have been established to promote and protect the social, educational and economic interest of the weaker sections of the society. These include the National Commission for Backward Classes 1973, the National Commission for Minorities 1993, the National Commission for Women 1992, and the National Commission for Protection of the Civil Rights 2007. The Criminal Procedure Code 1973 separated the judiciary from the executive in the public service of the state. Prior to the separation, the district authorities like the collector and the subdivision officer, the tehsildar and so on used to exercise judicial powers along with the traditional executive powers. After the separation of the judicial power was taken away from these executive authorities and vested in the hands of district judicial magistrate who work under the direct control of the state high court. The ancient and historical movement of the and archaeological sites and renames Act 1951 has been enacted to protect the monuments, places and objects of national importance. Okay, the primary health centers and hospitals have been established throughout the country to improve the public health. Also, the special programs have been launched to eradicate widespread diseases like malaria, TB, leprosy, AIDS, cancer, filaria, Kala Ajar, okay, Guinea worm, yams, Japanese encephalitis, and so on. Okay, laws are to prohibit the slaughter of cows, buffaloes have been enacted in some states. Some states have initiated the old age pension scheme for people are above 65 years. India has been following the policy of non-alignment and Panchshil to promote intellectual policy and security, peace and security. In spite of the above steps, the central and state government, the directive principles have not been implemented fully and effectively due to several reasons like inadequate financial resources and unfavorable socio-economic conditions, population explosion, strained state relation, and so on. Directives outside Part 4. Apart from the directives include the Part in Part 4. Some of the other directives contained in other parts of the Constitution. Claims of SC and ST to services, instruction in mother tongue, development of the Hindi language. The claims of SC/ST services. The claim of a member of the SC/ST shall be taken into the consideration consistently with the maintenance and effectively efficiency of administration in the making of the appointments to services and post in connection with the affairs of the Union and the other states. Article 335 in Part 16. Instruction in mother tongue. It shall be endeavored to every state and every local authority within the state to provide adequate facilities for instruction in the mother tongue at the primary stage of education to children belonging to linguistic minority groups. Article 350A in Part 17. Development of Hindi language it shall be duty of the Union to promote the spread of Hindi language and to develop it so that it may serve as its medium of expression for all the elements of the composite culture of India. Article 351 in Part 17. The above directives are also non-justiciable in nature, and they are given equal importance and attention by the judiciary on the ground that all parts of the Constitution must be read together. Article related to direct principle of state policy at a glance. Definition of states. 36 article. 37 article. Article 37. Application of the principles contained in this part. 38 states to secure social order for the promotion of the welfare of the people. Then 39. Certain principle of policy to be followed by the state. 39. Equal justice and free legal aid. 40. Organization of village panchayats. 41. Right to work, to education and to public assistance in certain cases. 42. Provision for just and human conditions of work and maternity relief, living wage, etc. for workers. 43A. Participation of workers in management and industries. 43B. Promotion of cooperative society, Uniform Civil Code 44 for the citizens. Provisions 45. Provision for early childhood care and education to children below the age of 6 years. 46. Promotion of education and economic interest of scheduled caste and scheduled tribe. Another weaker section. 47. Duty of the state to raise their level of nutrition and the standard of living to improve the public health. 45. 48. Organization of the agriculture and animal husbandry. 48A. Protection and improvement of environment and safeguarding forest and wildlife. 49. Protection of monuments, places and objectives national importance. 50. Separation of judiciary from executive. 51. Promotion of international peace and security. Promotion of international peace and security. Notes. Treaty principle article mentioned 38 to 51. Okay. Article 36 deal with in definition of states. Article 37 deals with from nature, significance of direct principle. Okay, given listed the Indian Constitution. Okay. Cornerstone of a nation, Oxford. The policy of state mainly maintenance of law. यहाँ पर दिया है डायरेक्टिव 42nd अमेंडमेंट एक्ट के बारे में. तो यहाँ पर देख लिविंग वेज, मिनिमम वेज. ठीक है, डायरेक्टिव वाज एडेड 42nd अमेंडमेंट एक्ट. ठीक है. कंट्री असेंबली डिबेट्स यहाँ पर देख सकते हैं. तो थैंक यू फ्रेंड.